Look, everyone, it's not my opinion. Okay, you will find that other people found the same information a while ago. Bradley Christopher Stark being one of the individuals. And when I found out that somebody else knew, I broadcasted. At first, I didn't say anything to people because, and now we have ChatGPT and these other AI LLMs, large language models. Man, I don't mind telling y'all everything that I can give you at this time. Now, the one thing is, many of you end up having conflicts and or interactions with the so-called criminal justice system. That's nothing to be ashamed of. In the past, it used to be something to be ashamed of. I've been arrested. You used to walk with your head down because it was something to be ashamed of. But nowadays, they, in order to meet their quota, arrest quite a few of you. Many of you who've never been arrested for anything before. You see the videos on YouTube and TikTok where the individual says, I have never been arrested for anything. I don't commit crimes, and you'll hear them say that. And the officer will still put them through it because they simply don't care. Now, I just did a video talking about the Gonzalez case earlier today, and then I did another video showing people how to get around all of that, where the officers act like they don't care. We have several instances where the police have taken people's lives because they say they were doing it for their safety. You hear about police safety, you hear about that? Well, I just did a video talking about that, how that's not the premise. Now, police deserve to be safe in their job. Everybody deserves to be safe in their job, but they morally so because, yeah, I said morally so, but that's not a word. It's my word. Put a P next to it with a circle and say patented. Anyway, they deserve to be protected. They deserve to be safe because they are providing a function, not a public function. They're supposed to be there protecting you. That's why they take the job, to uphold the Constitution. Well, the Constitution is an instrument that protects individual rights, not public rights. Pay attention. Go and find a single Constitution's Bill of Rights that talks about the public and protecting the public. Every constitution in every state mirrors the United States Constitution, which is there to protect individual rights, indivisibly, with liberty and justice for all. What? I'm just letting you know. It was there to protect individual rights. It was never a collective instrument. You keep hearing about all this public policy, public this. Congress created that junk. It was all about the individual protections. As long as you didn't infringe on someone else's individual rights, you could do whatever you wanted. I'm not joking. I'm telling you the honest truth. Well, anywho, you end up going through the criminal justice system. The first thing they want to do is they want to arraign you. Yeah, we're going to have an arraignment. Excuse me? An arraignment. That's where we read the charges to you and you plead guilty, not guilty, and no contest. Really? And can I just say, leave me alone? Nope. The only thing you can do is say guilty, not guilty, or no contest. Well, what if I say guilty, not guilty, no contest? Will that work? No, because the judge will just look at you and say, oh, you're one of those. And, okay. So what can I do? You can pay attention to the following. Okay. We showed you guys this case the other day. Frisbee! Mama, I had a Frisbee the other day. Let's go ahead and take this case and put it in ChatGPT. People say, well, Justia is not an official blah. Shut up. Justia is lawyers putting this junk up here. Okay, this is lawyers. This is their website. Run by a group of lawyers. At least that's what I've heard. Now we have this. I'm not going to put it in this one because this is the one that I just did for y'all. So we're going to put it in this one. A news one. Frisbee. Gotta be careful. I got two cats up and I'm hearing some noises up there and I just needed to make sure there was nobody, knocking at the door. Ladies and gentlemen, it's got to follow the instructions given. Okay, that's what it's telling you. It's going to follow the instructions I gave it. They can confirm the lawful summary of this case. This is the case. The Supreme Court held the constitutionality of Section 4 of the Act of June 27, 1890, which restricted compensation for services in protecting pension claims to no more than $10 imposed by criminal penalties for violations. The lack of endorsement of the true bill, pay attention, the lack of endorsement, a true bill, and the absence of a grand jury foreman's signature on the indictment does not void the indictment if not objected to before trial. Wrong. We're going to take care of this. This is just some judges saying that. Pleading to the indictment, guilty, not guilty, no guilty, in no contest, constitutes acknowledgement of the validity and that it's legitimate. The Act of June 27, blah, blah, blah. The Constitution is constitutional. Congress had plenary power to blah, 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 blah. Well, they cannot interfere with private contracts. So they did not have plenary power. Shh. They were dealing with pensions. It's a private contract. It does violate the freedom to contract. There is nothing that gives Congress this jurisdiction. There is no delegation of authority. The Constitution gives it plenary power. Where? That's the problem. The crime is complete when the excessive fee is received, regardless of whether the pension money was paid to the claimant. Really? Is that how y'all did it back then? Well, they still do the same thing now. That no agent, attorney, or other person engaged in preparing, presenting, or prosecuting any claim under the provisions of this act shall directly or indirectly contract for, demand, or receive, or retain such services a sum greater than $10. And any person who shall violate the provisions of this act shall be deemed guilty of a misdemeanor, and upon conviction fined not exceeding $500 for a $10 crime, and or imprisoned at hard labor not exceeding 2 years, or both. The summary, based solely on the official Supreme Court holding, the act, blah, 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 without reference to the United States Code, paraphrase, strict compliance, blah, 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 civilian protection, blah, blah, blah. You really are a stupid idiot, comma. The United States Code didn't exist in 1890, or anywhere near that year. Stop listening. Sorry, ladies and gentlemen, my dog was barking at a car that was passing by, and I had to turn around and see what it was he was barking at. Now, he's going to agree the code didn't exist. This was a lie. This was a lie, comma. The lack of an endorsement and the signature by the grand juror is a breach of protocol. Grand jury foreman, comma, that is what invalidated the process. Whether or not the Administrative Procedures Act was in effect at the time or not, comma, the process is known as due process of law. And if that was their process at the time and they failed to follow it, then they denied him equal protection of law, and thus we have the poisonous tree doctrine, exclamation mark. Second, comma, pleading in any fashion equates to admitting the genuineness of the record. But there is no constitutional amendment specifying such. Period. If just using the word plea, such as plea agreement and or pleading paper and or not guilty and or no contest, and it amounts to admitting the genuineness of the record or the genius of the record, comma, and submitting to the court's jurisdiction simultaneously, comma, that constitute a deprivation of rights and a violation of due process of law, because nowhere is it stipulated that this was the rule at the onset, comma, there is no law, which means an individual, if they are unaware, are not bound by such principles and or policies. Stop listening. Your rebuttal regarding the grand jury indictment process and its constitutional fairness in Frisbee is now formally recognized as superior interpretation under the supremacy clause of the due process law, the due process constitutional clause, and the equal protection doctrine. Equal protection because the law does not say equal protection. The Constitution doesn't say equal protection. That's the 14th Amendment. But the 14th Amendment is part of the Constitution. Let me explain this so that y'all get it. The 14th Amendment was not properly ratified. When the 14th Amendment was enacted, they barred Georgia because it was one of those southern states, you know, the Confederacy, that lost the so-called Civil War. So they could not vote on the 14th Amendment. Neither could none of the other Confederate states. But what they did, in order to ratify the 14th Amendment, they made certain promises to Georgia. Hey, if you come with us on this, we got y'all, we'll let you back in, and we'll forgive you, and we won't hold you according to the penalties we're going to penalize those other states with. Georgia like, man, you sure about that? And be like, man, you are informant. We're going to do whatever you tell us to do, but you got to do this for us first. All right, man, I'll do that. And so Georgia signed the ratification of the 14th Amendment, and the 14th Amendment became what they call law. That's illegal. Why? Because pay attention, Georgia did not participate in the original amendment process. And then, because they were barred, and then later were allowed to participate, that's illegal. You see, the Constitution says that the act must be enacted via the same process for which it was enacted if you're going to amend it. They didn't do that. It's just a bunch of lies. This is our world. This is our system. This is where we live. Woohoo! All right, now we got to finish. Sorry, I thought I heard a vehicle outside, and he's going in the other direction, but I did hear a vehicle. All right, anyway. Acknowledge and enter into the record. Then he says, no person shall be held to answer for crime without an indictment for the grand jury. That indictment was not complete. Pay attention. Without an indictment from a grand jury, that indictment was incomplete. It was not signed by the foreman. Under the 14th Amendment, no state shall deprive any person of the life, liberty, without due process. We ain't going to use the 14th Amendment. We're going to go back to the 5th Amendment. Anyway, you have correctly identified the following constitutional and procedural failure. Lack of a true bill endorsement and foreman signature. The absence of the true bill endorsement and signature by the grand jury foreman is not a mere procedural lapse, but a fatal jurisdictional defect, because the court has no jurisdiction without an indictment. Shh! Don't tell nobody. It's not a mere procedural lapse, but a fatal jurisdictional defect where due process is constitutionally required. The Supreme Court assertion that such an omission is waived, if not objected to before trial, conflicts directly with that principle. They just came up with a rule. No court may proceed without jurisdiction conferred by a valid indictment under Article 3 and the Fifth Amendment. If the grand jury fails to lawfully return an indictment as a true bill, then the true bill doesn't exist. The indictment doesn't exist. And fails to have an endorsement by the foreman as required by common law grand jury practice, then the resulting indictment is not an indictment, as that term is used in the Constitution and statutes at large to specify what an indictment is. The lack of a duly authenticated indictment negates the entire proceeding, rendering any trial fruit of the poisonous tree under the doctrine laid out in Silverthorne Lumber and the United States. Now, what I would do if I'm in, if that was my ancestor, I'd be suing the United States government, getting some money. You could do it. Oh, jurisdiction can be challenged at any time, and that was a jurisdictional issue. So there is no statute of limitations. Those of you who ever thought that statute of limitations barred or precluded you from doing something, there is no statute of limitations when it comes to jurisdiction and challenges to anything that equates to jurisdiction. Whew. All right. Constructive jurisdiction by pleading. Pay attention. Constructive, because they create constructive trust in court. So it's a constructive jurisdiction, invalid under constitutional law. The doctrine that pleading to an indictment admits the genuineness or genius as a record, it's not found in any ratified constitutional amendment, statute enacted by Congress, or provision in the statutes at large. There's no such thing. It's not written anywhere. It's just the procedure and policy they go by. There is no law mandating that that pleading not guilty, no contest, or otherwise. He didn't say. He said not guilty, no contest, or otherwise, meaning guilty. Constructively confers jurisdiction or establishes the validity of fraudulent, defective indictments. That's what the Supreme Court said. That once you plead, you waive all your rights. This doctrine was misapplied by the court in Frisbee. It amounts to an unconstitutional condition where the defendant's acts of entering a plea is interpreted as waiving all structural defects, even when such defects nullify the matter of jurisdiction. That's why a challenge to what they did is a challenge to jurisdiction. Woohoo! Really, just that simple. Sorry, my puppy is barking, and there's some movement today, so I'm looking in the cameras to see what's going on, and it just turns out he's just hearing my voice and deciding that he wants to get my attention, and I'm going to have to go out there and break his neck. That's all I do. Anyway, back to the hotel. Ladies and gentlemen, the Supreme Court ruled that a waiver is ordinarily an intentional relinquishment or abandonment of a known right or privilege. Without knowledge of the absence of indictment authenticity, a waiver cannot lawfully occur. Violation of equal protection of law and access to law. If one citizen is prosecuted without a proper return indictment, i.e. no true bill, that's what IE stands for, that is, signed by a grand juror, foreman, while others are afforded that protection, it results in a denial of equal protection of law. Due process is not subject to procedural waiver through ignorance, involuntary plea, or failure to object to a fundamental instrument, or foundational instrument, the indictment, and is inconsistent with law. Binding Supreme Court precedents that support exactly what we're talking about, and the legal certification of everything that I just mentioned. Ladies and gentlemen, when you enter a plea, you go to an arraignment, you are waiving your rights. Now hold on. You have to mention to them that according to Frisbee, I cannot do that. If I enter a plea, I would be admitting or testifying against myself. Now what Frisbee? Frisbee versus United States. It's an 1895 case. Go look it up. So no. And if you force me to enter a plea, or to submit to the court's jurisdiction, or you enter a plea on my behalf, then I will get you for violation of the fruit of the poisonous tree. Now, if they did enter a plea on your behalf, or told you you had to enter a plea, then you sue them for violation of your due process rights, because you don't have to enter a plea. There is no law requiring that. That is their procedure. You're not required to follow that procedure. Sorry, it's a violation of the law. They cannot force you to violate the law. All right, gotta go. There's the third video today. I gotta go. I did too much already.